Hello everyone, welcome back to our channel Law Point. This is Renu Thomas, your host. In the previous episode, we have seen what are the different ways in which the courts of law impose punishments and also the principles behind them. Today, we shift our focus to a very important aspect of the judicial process. Let us see how courts impose fines and what are the different methods used to enforce them. We have with us Mrs. Praseena Elizabeth Joseph, advocate on record from the Supreme Court of India, to explain the same. So let's watch this episode.
Fine is an important form of punishment. The courts impose punishment of fine with or without imprisonment. If you see the punishment for offences provided under the Bharatiyanyayasanhita, there are three ways in which the court uses fine as a punishment. First one is the punishment can be both imprisonment as well as fine. The second category can be imprisonment or fine, and the third category can be fine as the only punishment. Now let's see, if there is a punishment of fine and the person accused is not in a position to pay the fine, or if he doesn't want to pay it, then what are the remedies available under the Bharatiyanyayasanhita? In those cases, the accused need to undergo imprisonment in default of payment of fine. For example, if a person is punished for an offence of theft and is sentenced to an imprisonment of 3 years, and in addition to that 3-year imprisonment, there is a punishment with the fine of rupees 5,000. If the accused is not in a position to pay this 5,000, or if he doesn't want to pay it, then the court can direct the accused to undergo a further imprisonment of 1 month or 2 months in addition to the 3-year imprisonment. It is pertinent to mention herein that there are some limitations imposed on the courts while imposing sentence of imprisonment in default of payment of fine. Now let's see what are those limitations. First of all, when the offence is punishable with imprisonment as well as fine, then in that case, imprisonment in default of payment of fine shall not exceed 1/4 of the maximum imprisonment prescribed for that offence. For example, the offence of theft, the maximum punishment provided for that offence is 3 years. In that case, if there is a fine imposed by the court, then that fine shall not exceed 9 months. Thus, 1/4 of a 3-year imprisonment, which is the maximum provided for the offence of theft. So, in short, if a person is accused of an offence of theft and is punished with the maximum imprisonment of 3 years and with a fine of rupees so and so, in that case, that person is not in a position to pay that much of amount of fine, then the court can impose a punishment of 2 months or 3 months shall not exceed 9 months, which is the 1/4 of the 3-year imprisonment. Next limitation is, if the particular punishment is only fine and there is no substantial imprisonment provided for an offence, then in that case, if that accused is not willing to pay the fine amount, then the court can direct the imprisonment in default of payment of fine. Fine is under 5,000 rupees, then the maximum imprisonment can be ordered is 2 months. And if the amount of fine is under 10,000, then the imprisonment shall not exceed 4 months. And in any other amount of fine, then the imprisonment shall not exceed 6 months. Now let's see when this imprisonment in default of payment of fine shall terminate. As soon as the payment of fine is deposited before the court, then the imprisonment in default of payment of fine shall be terminated. There may be scenarios wherein the 3/4 of the payment of fine is deposited. Then in that case, he must be released within 1 month. For example, if the accused is directed by the court to pay a fine of rupees 10,000 and in default of payment of fine, a sentence of imprisonment of 4 months. And if that person makes 3/4 of the payment of fine, that is around 7,500 rupees, within the first month, then the court will release the accused after the expiry of that 1 month. If that person accused, in the same scenario, he pays half the amount of fine within the first 2 months, then after completion of the 2 months, the court can release that accused. It is pertinent to mention herein that in criminal cases, we know that once the accused dies, then there is no criminal liability. All criminal proceedings get abated, that means stopped, as against the deceased accused. However, in case there is any imposition of fine by the courts on the deceased accused before his death, and it can be realized from the assets of the deceased accused. Further, it is important to note that within 6 years of the passing of sentence or before the expiration of the main substantive sentence of imprisonment, or whichever is later, the amount of fine can be asked for and can be realized. Thank you.
I hope you liked this session. Thank you for watching. Meet you in the next episode.